This is a University of Otago podcast.
O tēnā koutou katoa, ngā mihi nunui kia koutou. My name's Jacinta Ruru, an Associate Professor here in the Faculty of Law. Welcome into the Law Faculty and to this special evening where we're hosting a very distinguished professor from the United States, Professor Gerald Torres, who is the Jane M.G. Foster Professor of Law at Cornell Law School. And so it really is my pleasure to introduce you, Professor Torres, who is a leading figure in the world working on critical race theory, environmental law and federal Indian law. He's trailblazed a path for many of us, including Indigenous law academics around the world, to have the courage to rethink mainstream legal thinking. And probably Professor Torres' most famous piece of work is his co-authored book with Harvard Law Professor Lani Guna called The Miner's Canary, Enlisting Race, Resisting Power and Transforming Democracy, published by Harvard University Press in 2002. And that book's been described as one of the most provocative and challenging books on race produced in years. Many of his articles have been published in leading American law journals, many with really engaging law titles, like Translation and Stories and Who Owns the Sky, which I just love. Professor Gerald Torres has served as Deputy Assistant Attorney General for the Environment and Natural Resources Division of the US Department of Justice in Washington, D.C., and as counsel to the then US Attorney General Janet Reno. So it's a great honour to have Professor Gerald Torres with us this evening to talk about a critical issue for us all, climate change, and in particular how the US courts are dealing with these cases. And I just have to mention the New Zealand Law Foundation that has provided the funding to bring Professor Torres into New Zealand here. And you've had a very short trip, first trip to New Zealand, and have spent 2 weeks. This is getting to the end of that 2-week cycle in spending time in particularly Waikato and in Wellington. And we only have him here for this evening, so for one day. So thank you for adding Dunedin to your trip and accepting this invite. And we're really looking forward to your talk this evening. Kia ora.
I don't, is it recording? Okay. I probably don't need a microphone in this small room. I first want to, by way of confession and avoidance, tell you that I'm coming down with something, so I really feel like I have only about 3/4 of a tank of gas. So if I run out of gas, towards the end, I trust you'll forgive me. I do want to hope that I'll talk for about 40-45 minutes, and then I'd like to open it up for questions and discussion. And I hope and trust that there will be questions and discussion. In fact, one of the things that's for me, interesting about this talk, and I know that sounds immodest, I guess, but I've basically given a series of two kinds of talks since I've been here, and one is on the foundations for a human right to a clean environment or a sustainable environment. And I thought of that in many ways as distinct from the talk about litigating climate change. But in fact, the reality is they're not quite the same talk, right? But there's certainly a family relationship between the talks. And so I'm going to, well, we'll see. I'll talk a little bit about the work we've done. But I want to, most importantly, talk about what I think is the theoretical structure behind the claims that we're making in the United States, but also the kinds of claims that could be made, in fact ought to be made, certainly in the Anglo legal jurisdictions, but probably, in my view, and I was actually thinking about this, any legal tradition that traces any of its roots back to Roman law ought to be able to at least access some of the arguments that I'm going to make today, and to the extent that even China considers itself a communist government. Well, you know, communism was founded on the theoretical structure of Marx and Engels, right? So in fact, it's a European system as well. And so that there's no legal system, except for perhaps indigenous legal systems, that are immune from the claims I'm going to make. There will be every legal system that objects to the claims I'm going to make, but they really center around a pretty simple question. And the question is, what is government for? Right? So that's really the fundamental question, because it's what motivates the litigation, it's what motivates the analysis, and ultimately is really the critical question. Now, I will say that there is afoot in international law the argument that the state owes no obligations to its citizens, or that in fact it's purely distinct, that the only thing it owes to its citizens is a maintenance of a market and the capacity to eliminate those kinds of legal devices that would exclude persons from the market. I refer you to the work of Philip Bobbitt, his seminal book, probably Shield of Achilles, and then his most recent book on Machiavelli. But I will say, despite the advancing of those arguments, they have not carried the day. And so there at least is some argument that has purchase among governments, that in fact the government is more than just a protector of market relations, but in fact has different obligations as well. And so I'll talk about that. About, God, I don't know, 11, 12 years ago, I wrote a paper called Who Owns the Sky? And the question I asked in that paper is really, all I ask are simple questions. It's really true. It's all I ask are simple questions. The simple question was, what is the nature of the air resource? Is it the kind of resource that is susceptible to private ownership? Right? Is it the kind of resource that, if you use normal distributional mechanisms, can be assigned to particular private individuals, private parties, private groups? And the answer is no. Now, what drove the argument, what drove the inquiry way back then, was the emergence of cap-and-trade regimes as a response to pollution. And the argument in the paper is pretty straightforward. The argument is that to the extent that you have cap-and-trade regimes in which the value that is gained by using some of the carbon loading capacity of the atmosphere, or the pollution carrying capacity of the atmosphere, to the extent that you have regimes that trade on that, the parties to the trade ought to include people who have an interest in the atmosphere, which in my view includes everyone who breathes. So that I argue that breathers have a claim And so no one has yet said that they don't like breathing, it seems to me. So the question was, on what theory can people who breathe, and that would, I assume, be everyone in this room, make a claim to have a seat at the table when this resource is being distributed or divvied up? Right? And the claim comes that is the government, which is setting up the market for these regimes, has got to include capturing some of that value, even as it reduces pollution. The fundamental obligation is to reduce carbon emissions, reduce pollution. But to the extent that it's using a trading regime to accomplish that goal, what it's got to do is capture some of the value of that trading regime for the people themselves, not for the state, mind you, not for the state, but for the people themselves. And so what I proposed in the paper was the creation of something I called then a sky trust. And the sky trust was a way in which the government could make an accounting to people currently alive and people who then came into being, right, that they would be able to cash out. And how you structure the actual trust is, of course, in some ways details, right? But what it would enable people to do is you could use the trading regime, in fact, to capture value for individual people in the particular countries in which the trading regimes exist, or if it's international, even international, at which point they could take that value and allow them to participate in the economy, go to pay for their college, start a business, buy a home, whatever they want to do. But they would be able to use the value of those trades. After all, we're sacrificing something that we have an interest in, the atmosphere, the air, right? They would be able to use that value to finance their own needs. And so that it would be a way of, that the trading regime could capture value for us, okay? Now, in order to do that, of course, I needed to make the argument that, in fact, the air resource is a res communis, which is the Roman law term. That is something that is beyond market relations to a certain extent. That is, it's beyond the alienation to private persons, right? And so the example that has come to us from Roman law is control over the foreshore, and I use that term just because I recognize it's there's something controversial about it currently in New Zealand. But the idea was that the state owns the foreshore and water. Certainly, the easiest thing to know is the navigational servitude, right? Is something that belongs to all of us. That is, private people can't interfere with the right to navigate. Right? That is something that is the state protects for our own interest. But certainly the foreshore and the land under the tidal lands are owned in common for the people. And even the United States has recognized that, so that when Phillips Petroleum entered into a private lease arrangement to drill for oil in the tidal lands off the state of Mississippi, not a state in the United States that is well known for its liberal attitudes towards just about anything, the state of Mississippi, in fact, objected, and the Supreme Court said the state of Mississippi is, in fact, right. That the leases that Phillips Petroleum entered into are, in fact, invalid, and they've got to negotiate them with the state, and the state has an obligation to negotiate those leases consistent with the interests of the people. Similarly, in Chicago, when the state of Illinois gave away the shoreline to Lake Michigan, the Supreme Court of the United States held that it was beyond the power of the legislature, the state legislature, to give away that property, because that property did not properly belong to the state, but in fact belonged to the people. So the next step in the argument, obviously, is to ask, what analogies might you construct that would allow us to think of the air right, as a resource similar to the tidelands or flowing rivers or the water that covers the tideland. And the thing that was interesting to me is once I started doing research, you begin to uncover many, many areas in American law where this idea has actually taken root. The one that in fact we have abandoned our obligation, but in fact began as a common resource subject to quite stringent regulation, was the radio spectrum. Right? Before the radio spectrum was a valuable commodity, there was no need to regulate it. Once the radio spectrum became a commodity that could be distributed and from which value could be extracted, right, in order to prevent chaos, a system for regulating the radio spectrum emerged. And one of the things that regulatory structure entailed was a requirement that the radio spectrum, even as it's distributed and allowed to be transferred in a private market like emissions trading, right, in a private market, had to be done consistent with the public interest. That's a little more attenuated now than it needs to be. Fishing on the continental shelf, and I can talk about a lot of other examples, but I want to step back now. Right? I want to step back now. And if you are in agreement with me up till this point, right, that there is a trust, there are some properties that are beyond the private market, for which the government ought to regulate or manage consistent with the public interest. One of the questions is, where does that public interest come from and how does it get articulated? I've already suggested that the public trust doctrine is an ancient doctrine that every legal system that has any roots in Roman law is subject to. But I want to suggest a different metaphor. That's actually not a metaphor. I want to suggest a metaphor. Right? Because what I want to ask is, what is the structure of rights? Now, admittedly, the United States has a written constitution, right? But just because it has a written constitution doesn't mean that the constitutional argument I'm going to make isn't also applicable to jurisdictions that have unwritten constitutions. But it's easier to make in the context, in some ways, it's easier to make in the context of the written constitution the United States has. Because the following is true. It's both empirical and theoretical, I suppose. But one of the things that the United States did, and subsequently, and you need to ask yourself about New Zealand, you need to ask yourself about the jurisdiction in which you live. But one of the reasons the American Revolution was so threatening to Europe at the time it occurred wasn't just that we kicked the monarch out of the 15 states that were proclaiming independence. It was that the document that we adopted in order to create the Union was radically different. That is, the legitimacy, the basis of its legitimacy was radically different. Because up until that point, the governing theory was that you had a state of unlimited powers and a citizenry or subjects of limited rights. And what the constitutional structure did was to say, no, that's exactly backwards. What you have is a state of limited powers and a citizenry of unlimited rights. Now you have the Bill of Rights, which enumerate those which were quite important. But remember why you have a written constitution. You have a written constitution so that you can memorialize those critical points of disagreement and say, this is the answer, this is the solution we're going to adopt for these points of disagreement. But for those things that aren't written, it means that there are areas of agreement that it's not necessary to articulate. And so one of the inquiries you've got to make is, what are those areas of agreement? What are the things that we all believe, that aren't required to be enumerated? The metaphor, of course, is you can imagine the Constitution being written, but those background rights, those background claims are in fact the parchment that the Constitution is written on. Right? So it's like this whiteboard here. The only reason I can express things on it is because I can write things on it, but the foundation of my capacity to communicate to you in a written form is the fact that there's a whiteboard there that I can write on. Right? And the Constitution in some ways is like that whiteboard that behind the agreements that were memorialized in the written form. Now you have the 9th and 10th Amendment. Now the 9th and 10th Amendment to the American Constitution reserve those rights that are not enumerated, right, to the people or to the states. Right? So what it suggests is that the written Constitution does not exhaust all of the rights that the people have. It merely says this is the starting point from which human rights, as my teacher Charles Black said, named and unnamed, might begin to take articulation. It, of course, requires that you look at the structure that's created in the governing structure that's created in the Constitution. And here, then, you have to ask, and conceitedly, this is quite, American-centric, and I apologize for that. Right? But I urge you to think about it in the context of your own country. Right? Certainly, one of the questions you had, couple of things happened. Right? You had the Articles of Confederation, which accomplished one principal thing, and that was the creation of borders. But it also created something that up to that point had not existed in the world. And what it created up to that point that had not existed in the world, right, is territory beyond the borders of the states that was federal territory. And so one of the questions that arises is, what are the background rights and obligations and rules that are going to govern that federal territory? Now remember that under American constitutional theory, the federal government is not a plenary government. Okay? Nonetheless, right, as to the federal territory, it had an obligation to govern consistent with the powers that it received from the states when the states ceded their sovereignty to the Union to create the Union. And so one of the questions is, what is the power that they ceded to the central government to create the Union? My argument is one of the things that they ceded to the central government to create the Union is, in fact, this obligation to manage resources consistent with the public trust obligation that is incumbent on all of the states. And every single state in the United States recognizes a public trust obligation. Some states have broad, Hawaii has a broad articulation of it. Other states, like Idaho, have quite narrow articulations of what the public trust duty is. But what is clear is there is no state in the United States that has disclaimed the obligation arising from the public trust. So that if the states, in fact, conveyed some of their sovereign authority as the successors in interest to the crown after the Revolution, one of the things that they conveyed to the central government, right, isn't just management of exterior relations, but in fact a public trust obligation to manage this thing that hadn't been in existence before. the federal territory, right? You have the property clause of the Constitution that gives you some guidance, but it's never been completely filled out. And so if, in fact, there is an obligation to manage this resource consistent with the interests of the people for whom the government was created, my argument is the idea of building on unenumerated rights allows us to create or gives us the predicate for creating the argument that these other kinds of resources, like the atmosphere, are within the ambit of those resources that the federal government ought to regulate. Now, Richard Epstein, who is a noted conservative legal scholar, was commissioned by the Cato Institute. And I don't know if any of you know what the Cato Institute is. I don't know if any of you know who the Koch brothers are, or have heard of the Koch brothers. They're a small family business in the United States that has an interest in libertarian politics, I would say. But they created the Cato Institute. In any event, they commissioned Richard Epstein to write about the public trust. And I have a sense that what he wrote ultimately wasn't completely satisfying. Because what he says is this. Now, you all know, and I don't know what the constitutional obligation is, but in New Zealand, but I anticipate that it's similar to the obligation in the United States. Right? One of the obligations is that the government can't take your property unless there is a public use for which it has taken your property, and unless it compensates you consistent with the value of the property for which that it's taking. Okay? So it's no property shall be taken for a public use without just compensation. And what Richard Epstein says is the problem of disposing with public property thus raises the mirror image of public use and just compensation questions under the takings clause of the 14th Amendment, or the 5th Amendment. And he phrases it this way: no public property may be transferred to a private use without just compensation payable to the public at large. Right? And if you take that idea, then you have to look at the regulatory regime that allows private parties, right, to make use of public resources and ask whether the public is getting the value in exchange for the private use of those resources. Now, that's obviously a complicated question, right? Because one could say, as I'm sure many governments would say, look, creating the obligation, creating the circumstances for jobs conveys a value to the public, and those jobs are, in fact, those jobs are the value that's been created to permit, in exchange for the permission of these private parties to use public resources. But the answer is that's not sufficient, right? Because you could say, in the takings context, look, we're going to take your property, but in fact, taking your property and putting it to this public use by conveying it to a shopping center is going to create jobs. And since you're one of the people who is going to benefit by the creation of jobs in the taking of this property, that ought to be sufficient value. Well, that has never been the law, and if you made that argument, people might beat you, right? Because it misunderstands the relationship between the particular action of the government and the responsibility of the government. Okay, so that the argument for the public trust is not just that there's this responsibility to manage the resource in a particular way, but that the people themselves ought to be able to make an accounting. Professor Epstein goes on to say, the language of the public trust is far more than an idle metaphor, because it's quite clear that the public officials in question cannot treat the proceeds of a sale as their own private property. Instead, they are required to hold the monies received as part of the public treasury, that is, for the benefit of all individuals who had, in the original position, some undivided interest in the property. And my argument is we all have an undivided interest in the atmosphere. And there is the necessity to make an accounting for the transfer of that interest to us. Okay, people say, yeah, Torres, that's a fine argument, right? But the constitutional structure itself prohibits it from being enforced judicially. Because if you enforce it judicially, what you're going to be doing is trenching on the legislative authority of the Congress. And one of the geniuses of the constitutional structure is separation of powers. That is, you have the various departments of government assigned to the duties that they have, and we anticipate that they are best situated to perform those duties better than the other departments of government. Well, one of the answer to that is, of course, that the public trust doesn't require, or at least enforcement of the public trust, doesn't require the legislature to do a specific thing. It merely requires the legislature to do what it is obligated to do. Right? So the remedy may be thought of as a legislative remand, or to think of it more pedestrian ways, it's putting something on the legislative agenda that the legislature would just as soon not be on the agenda. But the argument is that it is a fundamental obligation of the legislature to make this kind of accounting, and so at minimum the legislature has to publicly make an accounting for the distribution of this resource. Whether it actually has to, why it's going to permit the continued expansion of greenhouse gases, right, and thus threaten not just the capacity of those now living, but people who are not yet living, is a question they at least ought to be put to the test to answer. Fine, Torres, that's a great idea, they say, but wait, there's another problem. And the other problem is you've got this complicated legislative statutory regime called the Clean Air Act. And the Clean Air Act, in fact, has occupied the field. And if you want to regulate greenhouse gases, you ought to do what the president recommends and use Section 111D or Section 5 of the Clean Air Act or the PSD section of the Clean Air Act, and just go forward, given that the Supreme Court has said that greenhouse gases are a regulable pollutant, and use the Clean Air Act to regulate greenhouse gases. The answer to that, of course, is that would be fine if, in fact, the Clean Air Act actually spoke to the regulation of greenhouse gases in a manner that actually protected the interest at stake in the application of the public trust doctrine. A recent case, Utility Air Regulatory Group against EPA, stood for the proposition that the federal government can regulate greenhouse gases. And the president just issued yesterday, right, the report suggesting that failure to act is monstrously expensive and gets even more expensive as we delay. And on June 2nd, they unveiled their greenhouse gas initiative, which is really Plan B because we failed to get a greenhouse gas bill passed through the Congress. Okay, so we have all of those issues, and you have my provisional answers to those questions. But I'm going to suggest that there are other places we can look that give us some models for how you might regulate these resources and what the obligation is. Now, remember, the radical part of this argument, and it's not really a radical part of the argument, it seems to me, but some people think it's a radical part of the argument. The radical part of the argument is that there are limits, unarticulated, to the exercise of the legislative authority of the Congress. Just like there are legislative limits to the exercise of the legislative authority of the state legislatures. It seems to me that the structure of the Constitution presumes that there are limits to the regulatory authority of the Congress. The idea of unenumerated rights suggests that there are, to the extent that we can craft these rights in a way that are judicially cognizable, also offer a way to suggest outside limits to what the legislative authority is. Now, I mean, of course, you know, this is not new, right? You can think back to, I started with Roman law, but you could do Roman law, you could do Magna Carta, you could do the U.S. Revolution and the Constitution, you could do the Declaration of the Rights of Man, right? All of these things stand for propositions that government was not created to serve its own needs, but in fact to serve the needs of the people whose consent gives the government legitimacy. So, let me give you one last example, right? Now, I suggested that the management of the federal territory is the first example, but in fact that's not true. The first example really is in the encounter between the colonists and then the successors and interests of the colonists and indigenous people. Right? And so when you go back and look at the treaties, what you discover, right, is that there is one of the things I guess that's different between New Zealand and the United States is the United States always recognized a pre-constitutional political existence of indigenous people, right? So the Constitution does not by its terms apply to indigenous people in American law, right? In fact, they're external to the constitutional structure. Nonetheless, because of the treaties, in fact, that ended, and they're mainly peace treaties, right? Because it's important to remember that until 1871, Indians in the United States were a formidable military force, right? That these treaties convey resources, seed resources from the tribe to the federal government in exchange for the obligation of the federal government to manage these resources in the interest of the tribe. So what's created is, in exchange for the exercise of plenary authority over Indians, there is a trust duty on the federal government to manage those resources in the interest of the tribes. One of the reasons I'm a law teacher, I guess, is I do things like read every single trust decision ever made by the Supreme Court in relationship to tribes. I have to say it's not a pretty picture. It's not a pretty picture. Nonetheless, the principle is still there. The fact that it has not been honored in every case doesn't mean that the failure of the legislature to act honorably in relationship to indigenous people erases the obligation to act honorably. It might be a source of shame, but it doesn't erase the obligation. And so we have this, at least in federal Indian law, the idea that the federal government's legislative authority is bounded, at least on one side, by this trust duty. And my argument is, in fact, everyone who's a part of the polity right, has an interest in the government managing resources that belong to all of us in a way that maximizes our interest in that resource. Okay, one last point, and then we'll open up for questions. The point is, okay, that's great, but you're just talking about living people. The idea of managing it for generations unborn, right, would create obligations, kind of pre-commitment obligations on legislatures that clearly are not, at least theoretically, permissible under some political theories, and certainly under some constitutional doctrine. In fact, some people have argued that even thinking of intergenerational justice is as Bentham would say, nonsense on stilts, right? Because you can only have justice between two subjects, right? And since people who are not yet born have no claim on us, right, the idea of articulating it in the theory of justice doesn't make sense. Well, this is where recourse to Indigenous people again help us in two ways. One is, if you understand what a nation is for, right, and I concede that, you know, nation states themselves are under stress. But if you ask, what are nations for? Right, one of the things, therefore, is to create the conditions for the people currently alive to have the resources to reproduce the culture that they have created. Certainly the right to culture in Indigenous cases is both a group right, but it's a right that suggests that management of the material conditions that are necessary for the recreation of the culture is necessarily implied in a right to culture itself. And that right to culture is one of the human rights, named and unnamed, that the Constitution at least leaves an opening for. And so even though the idea of intergenerational justice might not make sense from a purely theoretical perspective of the idea of a liberal concept of justice, right? The idea that one of the things that is entailed in this obligation of the people currently living is to maintain the capacity for the people currently living to reproduce the culture within which they find themselves. Right? And culture changes, it's not frozen in amber. That it suggests that the current legislature, in its exercise of the public trust duty, has to take into consideration the impact of its activities on the capacity of those not yet here to reproduce the culture for which the legislature itself is acting. And these are the arguments that we've been articulating in the Children's Trust litigation. And I apologize, in Wellington, I could have read you from the brief that we filed, but in Wellington I gave the brief to somebody who came up afterwards. And so I can't recite the arguments precisely from my head, right? But we've had some success. We failed in the federal courts. And the question is, and the reason we failed in the federal courts is largely because the federal court that we were in front of rejected the idea that the federal government has a trust responsibility. So what we do next is open to question, at least at the federal level. I think the argument I've made is not crazy, and in fact does suggest why the federal government has a trust duty just like the states. But we've been successful in some states and unsuccessful in others. But some of the states that we've been successful in actually would surprise you. So the state where I've been living before I went to Cornell, Texas, you would not have anticipated success. But in fact, we did prevail. Washington State, we prevailed. And so on Mother's Day, about 2 years ago, right, we filed cases in all 50 states. And then a year later, we filed a case in the federal court. But the idea was filing it on Mother's Day actually was a propitious date, right? Because, in fact, what we wanted to link it to was the day that we celebrate, at least in American culture, right, the reproduction of the material reproduction of the culture itself. And the reason children are our plaintiffs is because everyone in this room, we could choose the hedonist alternative and go and live our life as though none of this mattered, because in fact we're going to be dead before it. The changes are so devastating that we will pay the cost. But our children and their children are in fact the beneficiaries in whose interest we exercise this trust duty. And so, in fact, the trust, while it is incumbent on the government to act in a way that is responsible to the people who are part of the polity, creates a correlative duty on us to act consistent in ways that those who are not yet here will have the capacity to make the decisions that we would like to be able to make into the future. Thank you.